And what I will present today is an upcoming article that I've just started working on, so any feedback is welcome, where I will take the key finding of my PhD, as Eduardo said, which is that EU counterterrorism has institutionalized profoundly or matured after these attacks, and that in my research opinion, that has impacted the UK's approach to the Brexit negotiations in terms of law enforcement and information sharing practices and cooperation. This is what I will aim to argue. I will only briefly touch upon that today because I thought it would be useful. I'm not quite sure from the audience how much people are aware of the 8 main topics of Brexit agreement on law enforcement cooperation. So I will start first with a little introduction, and then I will go through these one by one. And please excuse my very crowded slides. I'm happy to share them afterwards. Firstly, EU counterterrorism is very much a hybrid area of governance for the EU. The EU has no pure operational capacity that rests with the member states. So as such, it is almost foreseeable that the UK was not particularly eager to participate in a lot of governance instruments in this in the Justice Home Affairs domain. Its approach is very much cherry picking and opt-in and opt-out driven. So it already refused to join Schengen, and then from there on, it had a very selective approach. So it retained opt-ins and opt-outs, wherein sometimes it would opt out and opt into instruments after they were adopted. Sometimes it would do it while they were being adopted. For the Lisbon Treaty, it specifically had an opt-out of all 130 Justice Home Affairs instruments, and then opted into 35 of them, something that no other member state, I believe, would be allowed to have as a flexibility. But it already more or less shows that the UK wanted to, so it did see some added value in EU instruments, but not to full extent to where it thought it could pick what was truly useful and added value to its own national instruments. At the same time, the UK was a driver for certain UK governance instruments. In particular, the principle of mutual recognition, which was already proposed in 1998, and since then is the cornerstone for judicial cooperation. It was a driver for the Europol development, for the PNR database set up. It is one of the biggest beneficiaries and one of the biggest contributors to the information sharing. It participates in about 40% of Europol cases and between 15 and 20% of Eurojust cases. It has benefited significantly from the European arrest warrant, which reduced the average time for extradition from 2 to 3 months from 10+ months before. It benefited from participation in the Prüm Convention, which enables the exchange of DNA data, vehicle registration data, and wanted persons, which used to be a matter of weeks and became a matter of minutes. It is also the fact that it continued to opt into instruments. It continued to opt into instruments of the EU showed that it actually drew a benefit from them. So it's and the fact that it continued even after Brexit to opt into, for example, Prüm and the Schengen Information System shows that it highly prioritized the EU data. Just a few showing statistics. So in 2017, the UK accessed SIS-II 539 million times. In 2019, that was 603 million times. Through the European arrest warrant, Britain requested 2,741 arrests in other EU countries and receiving 14,553 only for the fiscal year 2019-2020. So this is just 1 year. And for between 2004 and 2016, almost 10,000 individuals were surrendered from the UK to other EU countries. So with the end of the transition period, the UK is estimated to lose roughly around 40,000 alerts and data points from the EU databases. So this will significantly affect the relationship between the EU and the UK. However, what I will argue today is that the UK was very much aware of the benefit it was about to miss. So as such, it fought really hard to preserve as much as possible. So the next two slides are related to my PhD. However, I will only briefly touch upon that because that is the political context of 2015-16. However, this was independent of Brexit. But I believe this is the framework politically that impacted the appreciation of the UK for EU instruments in law enforcement and judicial cooperation. So the picture we had before 2015 in information exchange was that there was no sufficient information being exchanged. Contrary to what's believed, the exchange did not start with the Paris attacks. It started before that with the persecution of foreign terrorist fighters traveling between Europe and Syria. So this began the practices of increased information sharing through EU databases. What was the flaw back then was that databases were not used with regularity and were not used symmetrically across member states, which would become much more structured through the experience of pursuing and preventing attacks in the next few years. The key event that I found in my thesis is that the Paris prosecutor from the Paris attacks made it necessary that Europol and Eurojust receive the data from the attacks. So Europol was made to be involved in the investigation, which also demonstrated further its added value. Further than that, the PNR package was adopted after a decade of being in the EU legislative pipeline. The Schengen information system was increasingly used and increasingly its added value was being perceived, and even intelligence services were making use of the data in there when they were discreetly surveilling certain individuals involved in terrorist networks. So then this fragmentation of data started being tackled also by the introduction of interoperability of databases, but as systematically there were a lot more strategic measures, a lot more updates of databases, etc. And then the intelligence network was also updated, which is informal and does not go through the EU. However, it was made much more structured. The long-term and more practice-oriented implications of this were that intelligence and law enforcement across member states got to know each other, got to trust each other, which was not the case, very much not the case before, and got to trust the EU and got to involve it also in its investigations. These cross-sector relationships were harvested in the process of common investigation cross borders. So in a way, there was an unforeseen consequence, unintended consequence, as these cross-border investigations just necessitated involvement from various authorities, cross-border, cross-sector, EU versus national, political versus operational. So all of these different divides that were there before got to be mellowed down and softened, including as I said, the political operational one. Practitioners got much more engaged with the EU. They learned to appreciate the EU channels and the EU instruments, potential added value in their practical work. And so they got engaged also in the updates of these measures and of these tools, which made them even better, because they were previously designed by policymakers and politicians. And suddenly the practitioners were getting much more involved. So they were part of this process of shaping the EU counterterrorism policy, tailoring it to their needs. So this created this, what I call a virtuous feedback cycle that created, the more awareness there was of the EU operational channels, the more they were being used. And the more they were being used, the more they were being updated and improved, and the more value and awareness was raised again. So this created this necessity of the EU instruments, and I believe that, and not only I believe, but it is visible in the UK's behavior, which was already undergoing the Brexit negotiations, that this was a priority for both the EU and the UK to find a working relationship. I believe, from my expertise, that the negotiated clauses in this regard, as far as law enforcement effectiveness is concerned, like another disclaimer is that I'm not a data protection expert, so I look at the effectiveness and efficiency of law enforcement cooperation, information sharing. So from this point of view, I believe that the agreement was very forward-reaching, and was probably the most forward-reaching agreement the EU has with a non-Schengen member state, a non-Schengen country. So these are the 8 main areas that I will go through now, that are also the 8, I would say, key instruments where the UK feels like it would lose onto due to Brexit. So it did really work with the EU very specifically on those 8 instruments to replace them with something functional that is similar enough to the previous arrangements through the EU. So firstly, the exchanges of DNA and fingerprints vehicles, that was formally done through Prüm especially, and to some extent through SIS-II. So the Trade and Cooperation Agreement now allows continued cooperation on this, and continued exchange, and even automated exchange of these type of data through the national contact points. So the UK needs to set up its own contact point for this. There is no real-time direct exchange of data. However, there is a sort of database which informs member states when another member state has searched information on a certain suspect. And then after that, if a match is confirmed, according to the national law provisions, the state holding the data may provide it to the other state. So it is not obliged, but it is there because there is a mutual interest in this kind of sharing. So this is possible for all these categories of data that were there in Prüm. However, before any such exchange will happen, there needs to be an ex-ante evaluation by the UK, and possibly even a pilot run for vehicle data, so that the EU is convinced that personal data is treated responsibly by the UK. And after that, in the meantime, it will report on its progress on that, and then the EU may decide that it will continue this cooperation with the UK. Another supposedly very useful tool for the UK that it was also very much behind from the beginning was the sharing of passenger name records, so the data shared through airlines, which is important. It was important for counterterrorism when it was set up, but it's also in general for missing persons or for cross-border organized crime. It is a very useful tool. So the TCA provides also for continued use here through new provisions, and it is subject to increased safeguards on the use and storage of data for the UK. So the UK may strictly process the data for preventing, detecting, or investigating terrorist offenses or serious crime, and it is obliged to delete PNR data once the passengers leave the country. And they are also required to provide the PNR analysis to EU member states contact points or to Europol and Eurojust in case they request that, so as to show how data is being processed, because there are limits to the treatment of this data, such as non-discrimination, prohibition of processing special categories of data. Also, the UK is supposed to notify passengers of the kind of use of data. It is obliged to depersonalize data every 6 months, but also to delete data every 5 years. And for this, there will be also a sort of pilot, because the UK has to develop its own system for treating the PNR data and depersonalizing it and deleting it after a certain time. And for this, it has 1 year on which a derogation is put. And after this 1 year, it's held accountable to treating the data a certain way. There's also an independent assessment once a year on the UK's treatment of PNR data. Even though the European Data Protection Supervisor has raised some concerns, especially about this transition period in which the UK will not be held accountable on the misuse of data. But there is visibly effort to keep this tool working, but at the same time to provide the necessary safeguards so it is compliant with the EU law. In terms of cooperation and operation.
Just to interrupt you, we have like 1 minute left.
Oh no.
Thanks.
Sorry. Yes, let me see. So yes, there are several other areas that are quite important, but where should I switch to conclusion then? So the cooperation on operational information is made available by special requests, also based on the Council of Europe provisions. Then the cooperations with Europol and Eurojust will be made available through liaison officer and liaison magistrate that will be posted on both sides between the agencies and the UK. The surrender procedure is quite important because it has replaced the European arrest warrant by a similar procedure that is based largely on the agreements with Norway and Iceland. But also as a non-Schengen member state, it allows quite a lot of, quite a strong framework between them. Then the mutual legal assistance is mainly enabled by the Council of Europe provisions, conventions, but also elements from the European investigation order. So there are efforts to introduce also EU provisions. The exchange of criminal records, which was also a tool quite used by member states in the last decade. So there is a new system set up that is largely based on this, only there won't be a real-time exchange, but it will be based on requests, and then the competent authorities are obliged to respond within a certain time frame of each other. This I will just skip. So to conclude, the added value of EU counterterrorism work has, in my opinion, and the terrorist threat of that period seems to have convinced the UK of the added value of EU instruments in this domain and bodies, which has affected the UK's approach to negotiating new provisions on internal security post-Brexit. And the UK seems to have wanted to keep the maximum amount of provisions available. Certain things like access to databases was no longer possible, just from technical point of view. Membership to agencies was no longer possible. However, it has retained access to Siena, the secure information channel of Europol, where also non-members can access. And it has been provided alternatives for a lot of instruments which it considers important. So the instruments that were able to be retained as a third state with the UK have been retained. The main concern is the longer timeframes for exchange, the loss of access to this real-time exchange that's available through the EU databases, and also just as a very general point, the European security governance, because this fragmentation might be demotivating to other partners, might be demotivating to EU partners between each other, because it gives a special status to the UK, and also gives a fragmented picture of European security abroad. So thanks.